Welcome to today's episode of An Interesting Case. If you're a returning viewer, welcome back. And if you're new, also welcome. And I hope you'll find the video interesting. If you do, please like the video and subscribe for more videos like it. Also, please be aware that if you want to read a written account of this case, the case is available in blog format along with the links to the source materials used at bylawhelp.com. Simply go to that website and click on the An Interesting Case link at the top in the bar. So with that out of the way, today's interesting case is the third in our series of videos for the case of the problematic poodle. In part one, we covered the incident in January 2020 involving the adult standard poodle known as Charlie, owned by Ian and Marguerite Suzette, which occurred in Kelowna, British Columbia. In that incident, Charlie had bitten and caused serious injury to a small dog named Spike, owned by a Miss Melanie Michaels. And this had led an animal control officer working for the Regional District of Central Okanagan to issue Mr. Suzette a $1,000 ticket for allegedly violating the Regional District's animal control bylaw. Mr. Suzette had disputed this ticket, but after a trial in provincial court, it had been upheld, and Mr. Suzette had been convicted of violating Section 36 of the bylaw, which made it an offense for a person to, quote, cause or permit, unquote, a dog to become dangerous. Following that, in part two of the series, we went on to explore how Mr. Suzette had appealed his conviction to the Supreme Court of British Columbia. On the appeal, Mr. Suzette had been successful at having his conviction and the $1,000 ticket quashed because the lower court had applied the wrong legal test. The provincial court had equated the fact that Mr. Suzette had let his dog Charlie run off leash, which is prohibited by the bylaw, with causing or permitting the dog bite incident, and the Supreme Court had ruled that this was legally incorrect. Although the Supreme Court did not dispute that Charlie met the definition of a dangerous dog, they found that in order to be guilty of causing or permitting the dangerous condition, a person must actively participate in causing it, or at least know of the possibility of it occurring and fail to prevent it. Since there was no evidence that Mr. Suzette had encouraged the aggressive behavior or knew that Charlie had aggressive tendencies, the Supreme Court had found no basis for a guilty verdict and therefore overturned the conviction. That was not the end of the legal disputes involving Charlie and the Suzettes, though. In the summer of 2021, before the appeal of Mr. Suzette's $1,000 ticket had even begun being heard by the Supreme Court, there would unfortunately be another incident involving Charlie, which drew the attention of the authorities and the legal system. And that is where we pick up again today. In July 2021, Danielle DeRoche decided to go on vacation with her family in the city of Kelowna, British Columbia. She rented a home in the city to stay in for a week during her vacation and brought along her Yorkshire Terrier named Nala. The rental home happened to be next door to the Suzette residence. After arriving at her vacation rental, Miss DeRoche saw that the Suzette's three poodles would run towards the fence separating the two properties in a manner that she considered unfriendly. However, nothing further occurred at this time. Later, on July 18th, 2021, as Miss DeRoche and her family were in the process of packing up to leave, she turned to find that her small dog Nala was now in the yard of the Suzette property, and Charlie had grabbed onto Nala with his jaws and was shaking her back and forth. Miss DeRoche jumped over the fence and rushed over to her dog to free her from Charlie's jaws, which she succeeded in doing. Unfortunately, in the process, Miss DeRoche did suffer some scrapes and bruises, and during the chaos, Nala bit Miss DeRoche on the face, likely due to panic. Nala also suffered some serious lacerations herself from the incident. Following this incident, the Regional District of Central Okanagan and its animal control officers took enforcement action, seizing Charlie the Poodle under authority granted by Section 49 of the provincial law known as the Community Charter, which, amongst other things, authorizes animal control officers to seize dangerous dogs in certain circumstances to protect public safety. They also laid a total of 7 charges against Mr. Suzette for alleged violations of the community charter and the regional district's responsible dog ownership bylaw, which can be summarized as follows. Number 1, on January 20th, 2020, It was charged that Mr. Suzette caused or permitted Charlie to seriously injure another dog while in a public place, contrary to Section 49, uh, subsection 1, paragraph B of the Community Charter. Note this charge refers back to the incident discussed in part 1 of our series, where Charlie injured the dog Spike, owned by Ms. Michaels. Mr. Suzette had been issued a $1,000 ticket for that incident, but as previously mentioned, it was later thrown out on appeal in the Supreme Court of BC. Count number 2, it was charged that on March 1st, 2021, that Mr. Suzette failed to obtain a dangerous dog license for Charlie as required by Section 11 of the Responsible Dog Ownership Bylaw. Count number 3, it was charged that on or about July 10th to July 18th, 2021, Mr. Suzette caused or permitted Charlie to become a nuisance dog, contrary to Section 34 of the Responsible Dog Ownership Bylaw. This would be based on the allegation that Charlie was charging the fence between the Suzette property and the vacation rental property next door, as it was alleged this made him a nuisance dog as defined in the bylaw. Count number 4, it was charged that on or about July 18th, 2021, Mr. Suzette did not keep Charlie in a locked enclosure as required for dangerous dogs under Section 39, subsection 2 of the Responsible Dog Ownership Bylaw. Count number 5, on or about July 18th, 2021, it was charged that Mr. Suzette caused or permitted Charlie to become deemed likely to kill or injure a person or domestic animal, contrary to Section 49, subsection 1, paragraph C of the Community Charter. Count number 6, on or about August 19th, 2021, it was charged Mr. Suzette did not have a dangerous dog warning sign posted on his property as required by Section 40 of the Responsible Dog Ownership Bylaw. And finally, count number 7, on or about August 19th, 2021, it was charged that Mr. Suzette did not have Charlie implanted with a microchip as required for dangerous dogs under Section 41 of the Responsible Dog Ownership Bylaw. In January 2023, Mr. Suzette went to trial in the Provincial Court of British Columbia on these charges, and that was heard before Judge A. Tam of the Provincial Court. At the very beginning of the trial, the judge found there was no evidence to support the possibility of a conviction for 2 of the 7 charges. This was because the sections in the Community Charter that were cited as the basis for these charges were not actually violations a person could be charged with. Rather, those sections were simply clauses which set out the definitions for a dangerous dog and procedures for dealing with dangerous dogs, including the procedure for having a court order the destruction of a dog. The lawyer representing the regional district as its prosecutor explained that it had not actually been intended to have a punishment imposed on Mr. Suzette for those 2 counts, but rather they were asking the provincial court to declare Charlie to be a dangerous dog under those sections and possibly order the animal to be destroyed. Mr. Suzette expressed surprise at hearing this, stating it had not been made clear to him that this was what the regional district was asking for. Based on the way the court document was written, Mr. Suzette stated he thought these 2 counts were like the other 5, asking for a sentence to be imposed on him, not his dog. Judge Tam agreed with Mr. Suzette's arguments and ruled that the way the prosecutor had written the 2 counts into the document with the other 5 was confusing and failed to give adequate notice to Mr. Suzette of what was being asked for. Consequently, these 2 of the 7 counts were dismissed, and the court went on to deal with the remaining 5 counts against Mr. Suzette. In the trial of the 5 other counts, Mr. Suzette raised some arguments that he had at his earlier trials, namely that his prosecution by the regional district and its staff was an abuse of process and unfair. He also argued that his dog Charlie was not a danger to the public and did not deserve to be labeled as such. Judge Tam rejected Mr. Suzette's argument that Charlie was not a dangerous dog. He pointed out that back in 2020, after the first incident involving Charlie, an animal control officer had served Mr. Suzette with a notice designating him a dangerous dog. He further pointed out that if Mr. Suzette wanted to challenge that designation, the proper course of action was to file an application for judicial review of the officer's decision, not to bring it up in the middle of a trial. Since the proper process had not been followed, the judge would not consider overturning the animal control officer's decision to designate Charlie as a dangerous dog. Judge Tam also went on to state that though he was not required to do so, he was personally satisfied that Charlie qualified for the designation as a dangerous dog under the law, and that the animal control officer was justified in making that designation. He stated that despite Mr. Suzette's claims that Miss Michaels may have accidentally injured her own dog when she was kicking at Charlie during the first incident, 2020, the logical conclusion was that Charlie was the one responsible for those injuries. He also clarified that although Mr. Suzette had been successful in getting his $1,000 ticket from that incident later thrown out, this was not because Charlie was not dangerous, but only because the accusation in the ticket, i.e., that Mr. Suzette had caused or permitted Charlie to become dangerous, had no evidence to support it. Respecting Mr. Suzette's allegations that the prosecution against him was an abusive process and motivated by a desire to cause him financial and psychological harm, Judge Tam also declined to endorse Mr. Suzette's arguments. He said he found no facts to back up these accusations against the regional district, its animal control officer, or the prosecutor. On the second charge in the list, that of Mr. Suzette not purchasing a dangerous dog license for Charlie, Judge Tam convicted Mr. Suzette. He said he didn't find Mr. Suzette's arguments persuasive, that it was a minor and trivial oversight, noting that he had only purchased the license a year later and only after being reminded by the animal control officer. On the third charge, which accused Mr. Suzette of causing or permitting Charlie to become a nuisance dog, Judge Tam found Mr. Suzette not guilty. The charge was based on the testimony of Miss DeRoche, who stated she witnessed the Suzette dogs charging at the fence, which would qualify as nuisance behavior under the bylaw. However, there were three problems that the judge had with this. Number one, he was not satisfied Miss DeRoche had sufficiently identified Charlie as one of the dogs running at the fence. Number two, he is not satisfied that charging at the fence had happened repeatedly, which was a requirement to meet the bylaw definition. And three, he was not satisfied that there was evidence to prove Mr. Suzette had, quote, caused or permitted, unquote, the behavior. For the fourth of the 7 counts, which charged Mr. Suzette with failing to keep Charlie in an enclosure as required under the bylaw for dangerous dogs, the judge convicted Mr. Suzette. Indeed, Mr. Suzette himself admitted to Charlie not being in an enclosure on the day in question, saying that he didn't believe he should be locked up in a cage because that was cruel. For the sixth charge, which alleged Mr. Suzette had not posted a dangerous dog warning sign as required, the judge noted Mr. Suzette had, in fact, put up a sign, but the sign in question did not meet the specifications set out in the bylaw. Instead, it was a sign which displayed a cartoon caricature of an animal and bore the phrase, quote, "Beware vicious beast," unquote. Consequently, Judge Tam convicted Mr. Suzette on this charge as well. On the final charge, that of failing to implant Charlie with a microchip as required by the bylaw, the judge also found Mr. Suzette guilty, noting that Mr. Suzette admitted to not having done this and failed to provide any defense. So the trial was now over. Out of the 7 counts originally charged against Mr. Suzette, 2 had been dismissed before trial for lack of evidence. He had been acquitted on 1 charge, and he had been convicted on the remaining 4. Some time went by, and in March 2023, Judge Tam passed sentence on Mr. Suzette for the offenses he had been convicted of. In total, Judge Tam imposed a fine of $4,000 for the 4 offenses and ordered Mr. Suzette to pay the regional district $7,000 to cover its legal costs. Additionally, the judge imposed a restitution order requiring Mr. Suzette to pay Miss DeRoche $1,000 for the injuries to her dog and herself. Finally, the court also imposed an order on Mr. Suzette which directed him to retain a dangerous dog license as required by the bylaw, to microchip Charlie within 15 days, to put up a proper warning sign within 15 days, and to either have Charlie's enclosure inspected and approved by an animal control officer with 15 days, or if a new enclosure needed to be installed, to install it within 45 days, and then within 15 days after that, have it inspected and approved by an animal control officer. And so there ends our series on Charlie the Poodle and the Suzettes. So what lessons can be drawn from this saga which stretched over years? I think it highlights that having a pet is a considerable responsibility, which can have significant legal consequences if things go wrong. It reinforces that if you're going to take responsibility for having custody of another living creature, you need to always be mindful of how that animal and how other persons and animals are affected and exercise due diligence. And this is for both legal reasons and ethical reasons. Having a pet is not something to be entered into lightly. I honestly wish Charlie the best and hope that in the future he and the Suzettes can avoid any further troubles, both for their own sake and for the sake of other persons and creatures who might be harmed. So thank you for watching. I hope you found the video interesting. And again, if you did and you haven't already, please consider liking the video and subscribing to receive more videos like it. Until next time, take care.